hard to find the words to express how honored I am to be here and just how excited I am because at heart, I'm a real constitutional law nerd, but so excited to have 2 days to spend just thinking about these issues and hearing from everybody and learning so much about the opportunity to learn so much about Indian constitutional law and your own perspectives on these issues. So I'm just thrilled to be here. Thank you so much, Professor Vasanti, for inviting me, for having this idea. We met sort of by accident in a way, and that's just turned out to be just a wonderful friendship and professional collaboration. I'm excited for the week ahead and also to see what comes afterwards. And thank you very much to the organizing team. The students here have been fantastic, very helpful, very welcoming, and just very supportive. So thank you so much. It's a real pleasure to be here. You'll hear, just from what you've heard so far, and I'm guessing the rest of the conference, quite a bit of overlap in what we're talking about and how we're sort of conceptualizing and thinking about the place of dignity in constitutional law, particularly in India, but also elsewhere. I want to start where you did, actually, with the Universal Declaration of Human Rights. Dignity appeared in a few constitutions before World War II, very sporadically, in Mexico, in Finland, a few other places. But there wasn't what you would call sort of a body of dignity law at that point. And where dignity really entered into our consciousness as a legal concept was in the aftermath of World War II, of course, first with the establishment of the United Nations. The Charter of the United Nations identifies several goals for the UN. The first is to end the scourge of war, and the second is to reaffirm faith in human dignity. So those two things were intimately connected. And then the Human Rights Commission, in developing the Universal Declaration of Human Rights, took that idea of dignity and sort of made it a centerpiece of the new sort of legal world order. And if you don't mind, I would like to just read to you, and you mentioned some of this, but I would like to read to you the opening language of the Universal Declaration of Human Rights. So just bear with me. And I know you know all this, but I think it's worth understanding just how important and impactful this language has been, and also, frankly, how radical it has been. So I'm just going to read a couple of passages from the preamble, and then, of course, the famous Article 1. The very opening words of the Universal Declaration of Human Rights is, whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. A few paragraphs down. Whereas the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women, and have determined to promote social progress and better standards of life in larger freedom, so invoking the UN Charter and sort of bringing that language forward. Now, therefore, the General Assembly proclaims this Universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations. And then begin the 30 articles that enumerate the Universal Bill of the Universal Rights, beginning, of course, with Article 1, which I will also read. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Now, again, I pause on this language because I think it is really extraordinary language, particularly if you think of it in its historical context. What the drafters of the UDHR were charged with doing was not just creating a Bill of Rights, like so many constitutional drafters have done, but really charting a new path. This is in the immediate aftermath. The embers are not even cold yet from World War II. right? And here they are, these men and women who've gathered from around the world to say, that was a really terrible thing we just went through. We keep doing this twice in our lifetimes. And we need to set a course for changing direction of humanity, right? It's a pretty tall order, right? And the idea that what they did was to accomplish that goal of changing the course of humanity was to say, let's start with the principle of human dignity. And human dignity is not just a good idea or some good feeling, that we all like our dignity, but it's the foundation of peace and justice and freedom in the world. I imagine this little idea of dignity, this little word of dignity, with this huge, unbelievably heavy burden on its shoulders, being the foundation of peace and justice and freedom in the world. And it's all sort of based on the shoulders of human dignity. So the idea of dignity, the work that dignity is doing in this document is as a pivot, essentially. Never before had the nations of the world come together to really try to change the course of human events, to lead us away from the habit of war and towards this garden where the dignity and worth of the human person could flourish, and where men and women live with equal rights in social progress and with ever better standards of living, standards of life and larger freedom. So this is a monumental moment, and it's focused squarely, sort of laser focused on the idea of human dignity. And what they say about dignity is, I think, really important, and also, as I mentioned, extremely radical. First, and you mentioned this also, dignity had been, for the most part, thought of course, as rank or status, right? Very important people have dignity, kings have dignity, nobles have dignity, but regular people don't. Well, that changed with the UDHR, right? And I don't believe that dignity, that idea of dignity was abandoned. I think what was recognized in the UDHR was that all of us, everybody, every single member of the human family in present and future generations has that same worth that was once reserved to kings and nobles, right? So it's not that we abandon the idea of dignity as worth. We just recognize it in every human being, and it's innate, in meaning, as a legal matter, meaning that it isn't given. It can't be taken away. It's just part of who you are, every member of the human family. And that's also an important concept in the sense that it makes it actually resistant to law. Law can diminish your status, but it can't take away your dignity if it's innate. It's a part of the human personality. Another thing that's radical about the UDHR is that the U in UDHR, the rights here are universal. Every person. Now, again, put yourself back in the mindset of 1945, 46, 47, a momentous time in Indian history, a momentous time in world history, and a time where that very question about, well, is everybody really, does everybody have dignity? Is everybody important? Was front and center, right? This is exactly what everyone was thinking about in the world. And the UDHR comes down squarely on the side of universal dignity, right? Emphatically and without any reservation, on the side of universal human dignity. Tied to that, but it's a separate and separately important point, dignity is equal in everyone. You might have said, well, everybody has some dignity, but people have different amounts of dignity. But no, the drafters of the Universal Declaration of Human Rights said, first of all, everybody has it innately, and everybody has it in equal measure. That is just extraordinary for that time, and frankly, still extraordinary for now, to make such a strong commitment to the equal worth. And I know you know all this. I know you've been studying this and you've thought about this, but I still think it's just one of those things that I think is so so dramatic really, that it's worth just pausing and remembering how important it is and how high a standard it holds humanity to. One piece of this question about equal dignity, there's a lot that can be said about it. People write books about it, etc. But one little piece that I just want to draw to your attention is that if everybody has innate dignity, so not given, but innate, and everybody's dignity is equal, that withdraws from all of us the power to judge another person's dignity. Now, if you think about, again, if you put yourself in the mindset of the people who were drafting this in 1948, they had just endured, and the world had just endured, unimaginable savagery, really, right? Unimaginable but real savagery. And savagery all over the world in all kinds of different places, but certainly the Holocaust was front and center in their minds. In the Holocaust in Germany was front and center in their minds. And if you think about what the justification for something like the Holocaust is, it comes down to, in a sense, and I don't mean to simplify something that's very complicated, but it comes down to, in a sense, the idea that one person can say, you're not worth as much as I am. Your life isn't worth as much as I am. And therefore, I get to make all kinds of decisions about what I'm going to do with your life because it's not worth as much. And again, that whole idea was withdrawn the moment the UDHR commits to a system, a human rights system that's based on the idea of equal and inherent dignity. Another thing that the UDHR does that I think is very dramatic is it connects the idea of dignity to the idea of rights. So all of this that we've been talking about was not drafted in some philosophical tract, right? This wasn't just, what is humanity? Oh, it's about human dignity. This was a universal Bill of Rights, granted non-binding, but nonetheless a universal Declaration of Rights. And in the language that I read, you see several times not just the idea of the inherent dignity, but of the equal and inalienable rights, the connection, the sort of the marriage between dignity and rights, that they're intimately connected, not the same thing, but intimately connected. And that's important also, because what the drafters of the UDHR were saying then was we need to reaffirm faith in inherent human dignity, but we don't just stop there. It's a legal concept. It's not just a nice idea. It's a concept that has impact, that has legal consequence and legal effect. So what the UDHR does is sort of two things that are twinned. One is it operates descriptively to describe what human beings are, human beings as having this innate and equal inherent dignity. But then it has a normative aspect. And the second part of Article 1, the first part is all human beings are born free and equal in dignity and rights. There's that marriage of rights and sort of the sort of embodiment of all these different concepts I've been talking about. But the second sentence is they are endowed with reason and conscience, okay, and should act towards one another in a spirit of brotherhood. So there's this normative aspect. Because we have dignity, we don't just sit around and say, wow, isn't that cool? We all have equal dignity. It actually should affect how we act towards each other. And this is what makes it relevant in law. I once read a book that I found enormously sort of insightful, and it was called Law's Relations. And the idea of the book was really to say that what law is describing relationships, people to people, people to things, people to concepts. But if you think about law, not as sort of this given set of rules, but about just describing relationships. And I sort of thought that idea was interesting. And you see it very explicitly in that second sentence of the first article of the UDHR. All human beings should act towards one another in a spirit of brotherhood or sisterhood, as it were. So there's consequence to this recognition of inherent dignity. Now, I think the aspirations of the UDHR were very high, were very noble. One could argue that they didn't quite work out that well because it turns out that the scourge of war, well, still with us. So I think it's hard to sort of evaluate the impact of the UDHR, whether it's relevant today. And part of the way you measure relevance is actually not by how much people talk about it, but how much people incorporate it into what they're doing, and then maybe even stop talking about it. So that's what's happened with the UDHR. I mean, it's still discussed a lot, but really the impact of the UDHR, the reason it itself is relevant and that language is relevant is because those ideas that are articulated so briefly and concisely in the preamble and the first article are with us today in so many different ways. So that language, those ideas have spread through human rights law, which is really the body of law that was specifically designed to protect human dignity. That is what human rights law is about, right? And so we see in the international treaties, the international covenants, the various conventions, all of the declarations and treaties of human rights are based sometimes, usually explicitly, but sometimes implicitly, on this notion of human dignity, specifically as it was conceptualized in the UDHR. We also see it in, you mentioned the European Court of, and the European Convention of Human Rights, where again, not explicit in the convention, but but has been read into the convention by the European Court of Human Rights as an essential part of the European Convention. We see it in numerous documents in the inter-American human rights system. We see it in the African human rights system. And we also see it now in the constitutions of the world, of course, primarily in India, but also in many, many other constitutions. There are about 194 countries in the United Nations. Somewhere between 160, 170 of them mention dignity in their constitutions. That's extraordinary, right? That's extraordinary. That's almost all of the constitutions in the world that talk about human dignity in one form or another in their constitutions. And the shift from international law to domestic constitutional law, I think, is really important also. And again, you all know this because you're living in it, but I just want to sort of describe to you or highlight how important this shift is. There are some cases, we were just talking about one of them, where the international human rights system issues opinions of one kind or another, right? But they're very few. Law doesn't really happen at the international level. It happens a little bit more at the regional level in some parts of the world, but even there, not that much. Where law really happens is at the domestic constitutional level. And even there are gaps, but still, that's where it happens most. So by shifting this idea of dignity from the international level, from a declaration that's non-binding into these binding treaties of international law, into the constitutions, we see a number of things happening. First of all, these constitutions get interpreted by constitutional courts, of course, right? So that gives the courts an opportunity to take this one word and elucidate and expand and apply it to real situations. So that's the body of law that we have. But again, just trying to draw your attention to the fact that this is a really important phenomenon, that you take this word and then you render it into binding law for the nation. By shifting it from the international level to the domestic constitutional level, another thing happens. Each court takes this one word that has this global significance and makes it their own, right? So dignity in Indian jurisprudence has a certain aspect to it, a certain flavor, if you will, and it's slightly different than the way the Colombian Constitutional Court, or the German Constitutional Court, or the Israeli Constitutional Court, or the South African Constitutional Court, et cetera, understand dignity. So it allows, by shifting it from the international to the domestic constitutional system, it allows each court to say, this is what it means for us here now. And that makes it more real and more relevant and more applicable. And then thirdly, it's binding law. International law has its troubles in terms of enforcement. So does domestic constitutional law, but much less so. It's binding law. So I think that shift from this word in this document to the constitutions of almost all countries is really significant. And it has resulted in this very vast jurisprudence of dignity. I'll make a few comments, just general comments, and I'll speak with a little bit more specificity in the next session. But at this point, I'll just make a few general comments about this global jurisprudence of dignity. First of all, it's geographically very broad. I mentioned in all the regional human rights systems, but also in these constitutional systems, we see dignity cases in every continent, in pretty much every country. And I say pretty much because I'm not sure if there's an exception to this, but I will say at least pretty much in every country where there is an active constitutional court that is engaging in constitutional review, there are dignity cases, even in the US. We see it in every legal tradition. We see it in civil law traditions. We see it in common law traditions. We see it in religious traditions. We see some court in Pakistan says, well, of course we believe in dignity because it's part of Muslim law. We see it in Israel. We see it in India. We see it in all these different constitutional cultures that have different religious or ethical or cultural contexts. And we also see it in secular law. And we see it in the regional courts. So it's geographically vast. It's also substantively vast. And again, you mentioned this a little bit. We see cases on dignity, and again, I'll talk about this in a little bit later, but we see cases on dignity that are really on everything that's of importance to people, from gender and sexual identity, to voting rights, to criminal law. Yesterday, I get my time frames confused, but I think it was yesterday, the Inter-American Court of Human Rights issued a milestone, and this is a situation where the word milestone, I think, understates how important this case is, about climate justice, establishing a right to a clean, to a stable climate, to a healthy climate. So a major case about climate justice, referring also to dignity rights in the context of the climate emergency. So we see it on, that's just a few examples. And again, I'll talk about this a little bit more later. Sometimes in these cases, dignity is an explicit right, like in the Constitution of Germany. Sometimes it's implied. It's not actually mentioned in the Canadian Charter of Rights and Freedoms, but the court has implied it. There are a few cases in the US where the court has implied dignity from the confluence of equality and due process law. Sometimes it's sort of constructed, if you will. It's somewhere in the Constitution, and the courts have sort of reframed it. Arguably, this has happened in the Indian constitutional context, where it's in the preamble, but then it's turned into something else in Article 21. This happens in France. Sometimes it's sort of pulled out. It's in the Constitution in a very minor way, and courts have said, well, have sort of built a lot into that one word. And sometimes it's not even a right at all, but a value. And sometimes it's more than one of these things. So we see it sort of operating in all these different ways in different cases. In some ways, it's exactly like other rights in the sense that it's a justiciable right. You can walk into court, you can say my dignity rights have been violated, and a court will listen and maybe render a remedy. In a lot of ways, though, dignity rights are very different from other rights. In some ways, dignity rights sort of stand outside, and this is a little bit like the UDHR operates. There's Article 1, so it's just one of 30 articles in there, but somehow Article 1 is really different and separate and meant to sort of presage everything that comes next, right? And so you see the same thing in constitutional law. In some ways, it's just another right. And in other ways, it's viewed as both the source of other rights and also the purpose of other rights. So we interpret this other concept in a particular way because it stands on the idea of dignity as a foundation, or because the purpose of this right should be read in terms of human dignity. Yes, please. Please. In a lot of countries' jurisprudence, dignity is absolute, and that makes it quite different from other rights. It's absolute in the sense that it's not subject to balancing. It's not subject to allowing the government to explain its justification or to justify its violation of dignity. You don't get cases where the court says, this is torture and it constitutes a violation of dignity. Now, government, what were your good reasons for engaging in it? Once you find a violation of dignity, the case ends. Because there's no justification. And related to that, but it's a slightly different point, dignity is inviolable. The state must find some way to accomplish its legitimate goals other than violating dignity. And that applies to everything from dignity-based torture and mistreatment to dignity-based discriminations or anything else, or violations of privacy or anything else. So, and then lastly, you see dignity as a right, but you also see it sometimes as a remedy, as the basis for a remedy. So the court might say that you have to, that the state has to establish a level for pensions, this is from a German case, that complies with human dignity. The courts won't say what that level of pensions is, but it'll say whatever it is, it must comport with human dignity. You see this in cases involving trash pickers and others, where the dignity violations are sort of so complex and interwoven that the remedy also has to address a whole panoply of dignity rights. And sometimes you see it sort of baked into the remedies. What's astonishing to me about these cases is, despite their great diversity, there's a great harmony among all these cases, what you might call an overlapping consensus, right? There's no definition, they're not exactly the same, but there's a great overlapping consensus of cases. In other words, there is, there's a phrase, I don't know if this translates here, but there is a there, right? There is something there to dignity. One of my con law professors used to use that phrase all the time. Some people criticize dignity as being too elastic, too amorphous. Ronald Dworkin used the word flabby from overuse. And it's true that dignity does have broad contours, but it does have contours. Dignity isn't everything. There are things that are dignity violations and dignity rights, and there are things that are not. So it does have contours. What's interesting about these cases is that in so many of them, the vast, vast, vast majority of cases, the courts don't need to rely on dignity to decide the way they want to decide. Almost always, there is another more specific provision in the Constitution, whether it's privacy or equality or due process or something else in the Constitution, that the court could look to and say this violates that clause of the Constitution. And instead, what courts are doing in these cases is saying, yes, it does, but also it violates human dignity. So it's a judicial choice to talk about dignity, to go and explore what dignity means in the context of these cases. So that gets me wondering why judges are doing this. They could make their lives much simpler and write, frankly, shorter opinions if they didn't sort of digress and talk about dignity. So the question is, why is that digression worth it? Why is it not really a digression? And I want to just posit a few hypotheses about this. Of course, I don't know the answer, or maybe there is no answer to it, but let me just suggest that dignity is doing some things in these cases that other rights cannot do. A few things. One, and again, you sort of alluded to this, but dignity makes a case human-centered. I feel odd saying that because it seems to me that law should always and invariably be human-centered, but apparently it's not. And sometimes courts will talk about efficiency or justice or some other abstract interest that trumps the human interest. And what dignity does in a case is it focuses the issue squarely on the human beings at issue and sort of compels or at least invites the judge to consider the issue from the perspective of those human beings. And often in these cases, those judges have very little life experience that's shared with the human beings who come before them. And what dignity does is it reminds them that we are all of equal dignity. So I need to understand this case as if I were in your shoes. And that's sort of an important thing for judges to do. And if dignity is doing that work of sort of bringing judges along to the other side, then that seems to me a really good thing. I'll give you just one example from this case, this Inter-American Court case. It was an advisory opinion, so technically it's not binding at all, even compared to other international and regional law, it's not binding. But the court in this case was, the case arises out of a request from Colombia and Chile to identify the state's obligations with regard to climate change, right? What are states supposed to do given climate change? And I won't go into detail in the opinion, but I will say that in deciding this case, and it took about 2.5 years from the time the petition was filed to yesterday when the decision was issued, the Inter-American Court held a series of hearings during which it received more than 260 amicus briefs and heard from over 160 delegations. And it held hearings in different parts of the Americas, one in Barbados, one in Brasilia, but also one in Manaus, which is in the center of the Amazon. Very hard to get to unless you happen to be in part of an indigenous community. And then it's well, not easy, but it's there. The point is that the court, in making this decision about what were states' obligations with reference to climate change, the court understood that it could not do this job unless it heard from all kinds of people. That's a procedural way of thinking about this issue of dignity being human-centered. The opinion itself sort of reflects that in a lot of ways. Okay, so first, it's human-centered. Secondly, dignity is the guardrails of constitutional democracy. Right? The Constitution itself is supposed to be the guardrail of democracy, but dignity is what's doing the work in the Constitution of limiting, frankly, what a majority can do. This is why we don't have pure democracies where a majority of the people can do whatever they want because they're the majority. There are constitutional limits on that, and human dignity is the principal one. So we see this in cases about individual freedom, say in speech or capital punishment or other forms of punishment, where the legislation may reflect what people want, and the court will say, yeah, that's right, but it violates human dignity to treat people like that, and so you can't do it. So it performs this function of being like a guardrail. This is in the US right now, there's among the many controversies, one is about due process and who is entitled to it and whether it's sort of dignity-based in the sense that everybody is entitled to it or whether it's based on something else. Third, dignity is progressive. It's always moving forward. You recall the language from the UDHR about better standards of life and larger freedom, right? It's got this push towards progressivism. I've wondered whether dignity whether embedded within dignity is the concept of non-retrogression, that once you've established a dignity right, you really can't go back, that dignity is always moving forward. Connected to that is that it can be culturally transformative. And again, this goes back to the UDHR. The purpose of the UDHR was to say, oh, we were in this place where we kept having world wars. Let's pivot and move to something different, reject what we've done in the past. And that all that language that I called radical before is really language of transformation. It's saying we can do better, we can do differently. And you see that notion of transformative justice in so many cases involving dignity, where it's used as a lever, often to depart from very well accepted, very well entrenched, often religious commitments that had been accepted for whatever decades, hundreds of years, millennia. And then a court comes along and says, yeah, I get that. I understand that it's all what you've always done. And yet it violates human dignity, so it can no longer be done. The very first case in which the European Court of Human Rights identified dignity as a value in the European Convention, even though it wasn't explicit, was a 1995 case about marital rape, where a man was prosecuted for marital rape. His defense was, come on, everybody does this. We've always done this. We've always had the right to do this. The court agreed completely with that factual statement and then said, and yet it violates human dignity. Dignity is embedded implicitly, the very essence of the European Convention of Human Rights, so it's no longer acceptable. This is just a very dramatic illustration of that transformative, that pivoting power of dignity. The last thing I want to mention about the work that Dignity is doing in these cases is that I think, and this may be obvious, but again, I think it's sort of worth pausing on the mechanisms for how this works. Dignity is extremely empowering, right? It's empowering to people. That's the whole purpose of it. That's the purpose of it in the UDHR. It's the purpose of it in constitutions, and it's the purpose of it in constitutional law. It is meant to expand the capacity of each individual, not only to live a better life and larger standards of freedom, but to engage in a social and cultural and personal and political community, right? To allow each person to be part of a community, to not have people who are literally marginalized on the margins of society, but to bring everybody into the polity, because every person matters. So in a lot of ways, sometimes explicitly, often implicitly, the courts will use dignity to sort of buttress the notion of citizenship. And I mean that sort of with a lowercase c. I don't mean citizenship in the formal way, but being a citizen, being a member of a community. And in that way, when judges are advancing dignity rights, they're really expanding the democratic space, the space in which democracy happens. They're expanding the number of people who are part of the democratic polity and expanding the activities that those people can engage in to expand the space of democracy. So it's an interesting sort of push and pull if you think about judicial activity or activism on the one hand, and often we see that as limiting democratic space, but in the context of human dignity, where the courts are using the fullness of their powers to expand human dignity, what they're really doing is certainly not arrogating power to themselves, but arrogating power to the people. And we see that with respect to cases about social rights. We see that with respect to cases about education in India as well as elsewhere. We see it with respect to procedural rights. We see it in all of these cases where dignity is being used to empower people. I don't believe that dignity is, as someone once asked me, if it was just turbocharging other rights. In some ways, maybe, but not really. It's often sometimes described as a Swiss Army knife. It's just like the thing you pull out when you don't know what else to use. And yeah, look, there's a tool that can help you with this. And I don't think that's what dignity is either. I think what dignity is in these cases is a tool that gets the very, very hard parts of the job done, where nothing else, no other concept in law can really do that work. It's the tool that you use when you're thinking really hard about how to bring the law closer to justice. And I think it can be very useful in that way. And I'm really excited to hear more as the conference continues. Thank you very much.